Okay, so we're going to talk about the whole thing, impact of AI on the planet. So it's my pleasure to introduce Joshua C. Gellers, who's the inaugural faculty fellow for artificial intelligence and professor in the Department of Political Science and Public Administration at the University of North Florida. Joshua is that professor. He's also an expert with the Global AI Ethics Institute and a member of the IEEE Working Group on Design-Centered Human-Robot Interaction and Governance. Josh's research focuses on the intersection of environmental governance, rights, and technology. He has published over 24 articles or chapters, edited a special issue of Earth System Governance on AI and Digitalization, and written 2 books, The Global Emergence of Constitutional Environmental Rights and Rights for Robots, Artificial Intelligence, Animal and Environmental Law. And these were, even a few years ago, so really ahead of his time. And as well as editing a unit on environments for AI and society with Oxford University. So just my pleasure to be introducing Joshua, and then we'll be having a little bit of a moderated discussion.
Thank you so much. There we go. Green light means good, right? Okay. So thank you everyone for being here. As others have kind of echoed, just by attending, you're kind of at the vanguard of what I think is a very interesting, productive, and necessary conversation about the intersection of AI and I'm going to talk about environmental law, but obviously, of course, animals. Also, thank you to Kathy, Jamie, and Joan for having me here and inviting me. It's really an honor. And again, I hope that this is sort of the start or continuation of this conversation, but definitely not a place that it ends because some people I know already in this room are kind of pioneers in this area. But to give you very briefly, kind of broad sense, is so marginal in the conversation of AI ethics, which is unfortunate. But that's why I hope that we use this as an opportunity to galvanize more interest, more scholarship. I know there's plans for an edited volume, a special issue, maybe an edited volume too. Who knows? I'm certainly editing one, so if you have ideas, let me know. But anyway, I'm going to go into talking about the sort of areas that I'm most familiar with, and then I know that we want to keep it a bit more freewheeling, so I'm going to try and be more dynamic and inviting conversation and questions and even debate. So hopefully we can have a good generative discussion, if you will. So I think one thing that's I'll just highlight here is that, as you mentioned in the introduction, I'm my university's inaugural faculty fellow for artificial intelligence. About a third of the universities in my system in the state of Florida have some permutation of this kind of role. And even if it's not related to animals, I'd be happy to talk about that too, because I give a lot of talks about like how we came up with an AI strategic plan for the university and things like that, which you may be thinking about in your own institutions. So what I wanted to focus on for today are primarily 2 things. First, in what ways do environmental law, animals, and artificial intelligence intersect? And then how can we bring them into productive conversation in order to protect the interests of animals? Again, because this is such, as you probably heard from my comment earlier, a rather marginalized conversation within the broader ambit of AI ethics. And I think if you were to go to any of the major AI conferences, ACM, NeurIPS, I would be surprised if you came across a single paper focused on animals. So this is an act of bravery being here, but also I think we should all consider ourselves as infiltrating those other spaces where they need this kind of discourse to happen, because we know that if we leave it to the engineers, they will simply do what they are told by their bosses, and they will not think about the broader ethical ramifications of model design, AI deployment, and so on. Not to throw any shade on AI engineers, but. So the journey we're going to go on is to look at, although by no means is this an exhaustive list of existing legal frameworks and how, if at all, they kind of talk about animals. Then second, to talk briefly about the environmental impacts of AI systems on nature and animals. And then I will say the least well-developed part here is to identify some pathways for addressing gaps in the law, some of which you may have already some pretty robust ideas about. I'd be happy to hear about them. The first legal framework I want to talk about, I used rights of nature here, but you could maybe think of this more broadly as ecological jurisprudence, the work of people like David Boyd, Craig Kaufman, Pamela Martin. And we mentioned legal personhood. This is something I've written on quite a bit. I have some good recommendations if people are curious. The main idea, this is coming out in an article, chapter, where I sort of distinguish different kinds of interventions in legal personhood. But basically, rights of nature is kind of this catch-all term, which refers to either legal personhood for nature or legal rights directly for natural entities. And those can be discrete, like this river, or it can be entire ecosystems. And that is really jurisdiction specific. There are very limited ways in which animals have been brought into this frame. Again, most of the time, when we talk about rights of nature, we're focusing on either individual natural bodies or entire ecosystems. It is very rare that animals are even mentioned as part of that. Part of this, I would argue, is actually the fault of animal rights people, who have focused so much on the individual animals that it has become something of an awkward relationship between the more sort of ecosystemic, ecocentric people. And I think that more productive work needs to be done to kind of bring those into conversation. Of course, I have examples. There are very few, but I like talking about them, where we see that, like, sort of moments of contact between animal rights and the rights of nature. The famous Estrellita monkey case in Ecuador, although I was reminded by people that actually the amicus brief submitted by Harvard says basically, yeah, but the reason why we care about this is really because it's a sentient being, which is not what I'm trying to advocate for here, but it is probably one of, if not the only case that I'm aware of that brought the idea of rights of nature to a specific animal. So that's pretty important. Then in terms of legislation, there's the sea turtle law in Panama, which talks about the rights of the habitat. And so it has been argued that the sea turtle habitat, the sea turtles have rights by virtue of the habitat that they're in. So it's a very unusual way of framing it in terms of the law, especially in terms of rights of nature ordinances in the United States. They don't look anything like that. And then I would be remiss if I were to not mention some pioneers in this area who have actually informed me in my writing. Farv and Ava Burnett Kempers are a couple of people who've done excellent work that I really rely on pretty heavily. So, but persistent gaps that we have in the rights of nature framework include that it largely excludes AI and animal welfare. Again, it's focused almost too much on sort of big picture without looking at what are the animals within the habitats. And of course, there are the issues involving those animals when we think of discriminating between those on the farm, which we talked about here, those in the wild, those in captivity. Again, and I'm extremely critical of animal rights, which I think has largely been frozen in time since the 1970s. If anything, my goal here is to help disrupt some of those ideas, and I think that there's a lot of you who share some of those sympathies. But I do want to mention that there is this kind of nascent effort to bring AI into the fold of rights of nature, and so I wanted to give a couple of examples. Of course, not any from current legal practice. I have not yet seen or heard about any efforts, either in terms of jurisprudence or legislation, that talk about the rights of nature and AI. I'd be happy to hear if there are. But right now, in the areas of scholarship and the design of voluntary standards, that's where I see work being done. So this is a wonderful article, or a draft piece by Andre Uhl, called Earthbound AI Governance and the Rights of Nature. And it's really the first work that I've seen that tries to bring these two things together. It is extremely impressive, and I say that as someone who's been writing on the rights of nature for a while. And if you're interested, I would encourage you to check out, if not also join, the IEEE section I'm part of that Andre runs, which is called P7019, Standard for the Implementation and Governance of Autonomous Intelligent Systems Related to Earth Law Principles. That's been around for about a year now, and meetings happen every month. And the idea is to take what we understand about the governance involving AI and figure out if we can infuse it with the sensibility of Earth law. So this is like extremely innovative, and I think it'd be worth checking out for anyone who is interested in this union of AI and the rights of nature. One thing I'm very familiar with as sort of one of the earlier advocates or participants in this is coming from what's called the Earth System Governance School. There's a sort of nascent movement within that called Earth System Law, which basically what it does is it borrows ideas from Earth system science in terms of governance principles, and seeks to inform how we govern our systems, but with a kind of environmental sensibility. One of the things that we've already talked about today, and obviously from yesterday based on the comments earlier, is that it invites a conversation about expanding the subjects of governance. Those can include both natural beings and AI artifacts, as I argued in an article. And then how does this work kind of intellectually? The best way to explain this is, if you think about the Earth system, people in Earth system law talk about different sort of spheres. And among them are the biosphere, which is where we have the entire biological world, and then from philosophy of technology, a technosphere consisting of what they call a mental world, which encompasses artificial intelligence and technology. I talk about this in a piece that I have that's coming out soon, and based on the work of the recently deceased scholar Justin Donhauser, I add to this what I call robots as nature, or robots as ecology. And the idea is that there are some systems that are so broad in scope, that touch on so many things, that it is really sort of intellectually incumbent upon us to think of them as the sort of ordering principle. And so from science fiction, which I just talked about a couple days ago in Japan, we can think of Westworld and the Rehoboam, like sort of AI encompassing unit. And so the technosphere is this sort of acknowledgement from folks who kind of, again, look at Earth system science, that actually, if we believe in the concept of the Anthropocene, in which we have a new geologic era which is informed by human impact on everything because of sort of the artifacts that we've constructed and so on, that it makes sense to think of a separate and sort of related technosphere, which is the sort of housing point for all technology and how it interfaces with the natural and built environments. And so this is a sort of, I would say, not agenda setting, but an update on Earth system law that's fairly recent that I participated in Earth system governance. And it looks at new frontiers in legal science and sort of charts a path for how we might re-envision the law based on the understanding that Earth system law brings to that conversation. Then there's one that which you haven't heard about it. It makes sense because it hasn't been published yet. But a couple of years ago, there was this conference at University of Mannheim in Germany that I was invited to speak at, where the organizers, Birgit Peters and Niels Schacks, talked about developing a new kind of discipline within law called law in nature, because we have, for instance, law in economics. Why not law in nature? And so there's going to be a special issue of Reciel coming out. I think my paper is the first one in it, so hopefully by next week. That is sort of sketching out what we mean by law in nature. But basically, the snippet is that it proposes a fundamental shift in the way that law operates. It incorporates nature-oriented, holistic, and ecocentric perspectives using scientific insights. So unlike Earth system law, which is very sort of Earth system science focused, law in nature is more exclusively law-centered, but informed by science. And I would say, importantly for present discussion, it interprets nature in sort of variable ways by looking at it in terms of the sort of more than human, which is a phrase that I use most often, or other than human, which is inclusive of both animals and ecosystems, again, in an attempt to build that bridge between very individualistic animal rights and the very ecocentric rights of nature. So you probably already know a lot about this, so I don't need to spend a great deal of time, but this is a brief overview, right, of some environmental harms from artificial intelligence, water consumption, energy intensity, land and ocean use, and of course, raw materials. But one thing that I think gets lost in all this, and I've written about it in a recent piece in AI and Society, is there's a lot of conversation about the environmental impacts of AI that are taken for granted and not really probed in terms of their veracity. And so we have a lot of critical problems around trying to actually identify what those environmental impacts are. And I've identified some of them here, but I include them in my article. So disclosure is voluntary. No one is presently requiring companies to disclose their environmental impacts. And so what we see is the Wild West of that. Every company, Google, I think, was sort of the first actor here, sort of alleges that they're actually quite environmentally benign. They have their own estimates. There's the famous 5 cars estimate, which lots of people take issue with. if you are very online, like on LinkedIn, like I am, you will see this sort of back and forth between Sasha Lucione and Amy Lures at Microsoft, constantly arguing about what the actual environmental impacts are. So disclosure efforts are piecemeal, they are uncertain, and they are incomparable. So when you are trying to compare two companies side by side, you cannot do it because they are voluntarily disclosing their environmental impacts using different kinds of metrics. So it's basically a fool's errand. And this, from Hugging Face, gives you a sense of where we're at, where's the state of science and disclosure. So this is an environmental transparency kind of longitudinal analysis, and there's a link to it here with the QR code. And so you can see the number of companies that disclose direct, indirect, or not at all. And you can see that the none is quite a substantial portion of that. And here we are in 2025. And as the last time that I pulled this from the website, which was just a week ago, the only companies that have disclosed as of this year are those that talk about the indirect environmental impacts or not at all. So that is the state of science on the environmental impacts in 2025. Not very, assuaging if you have concerns about understanding that. But the reality is, as I argued in a longer piece, that what sustainable AI needs to do is take lessons from voluntary environmental governance. We just heard about in the previous panel, using things like labeling standards. Yes, right? So Hugging Face is doing that, but only in the case of energy, right? Their energy score doesn't address all of the voluminous impacts. The idea that there could be one that's animal focused is really interesting. I promise you none of them are talking about that. So again, even more reason why this conversation needs to be brought out to the larger AI industry and folks who are writing about sustainable AI, because animals are not on their radar. And I think we risk a huge oversight here for ethical reasons if we don't make sure that that gets brought into that conversation. Again, I apologize for not having been here yesterday, so forgive me if you've already kind of covered this, but we can maybe able to categorize the harm that AI poses to animals in three areas. One is direct physical harm, so direct impacts from AI deployment. My favorite example of this is optimizing milk production in dairy cows in the Netherlands, but there are many others. Intensive farming algorithms, which Yip-Fei talked about. Habitat loss, right? Erosion or elimination of natural habitats due to AI infrastructure, expansion, and resource use, and then also ethical violations, which I was really glad to hear Oliver mention before. Something that I've been thinking about for a while, and someone brought to my attention a paper on privacy of animals, which I was thinking about, but didn't know anyone had actually written about that. So things like the bias, how it can negatively impact certain animals. We heard about that in the context of autonomous vehicles. Privacy violations, which I just mentioned, and assaults on dignity, right? We think of, especially dignity law focuses primarily on humans. Again, you already heard me being critical of human-centered anything, but we might think of animals as having a kind of dignity as well, and the use of AI potentially poses a threat to that as well. So this could be a much longer slide, but I've tried to synthesize it into something that's a little bit more bite-sized. What kind of legal adaptation strategies do we have for a world in which artificial intelligence is posing kind of existential threats to not only the world as we know it, but also some of the erstwhile concepts that we tend to think of as sort of structuring our legal systems? Broadly speaking, I think we can look at them from kind of two different vantage points. And I think both of them are valid in their own ways, and I'd be curious to hear what your perspectives are. One is kind of a status quo model. We repurpose existing legal constructs. We don't need to invent new ones. So the idea is that we can, in fact, go into antiquity and find, in rem, we heard, about ships a moment ago, which I wrote about in my book, right? You could use in rem proceedings to talk about these things. Joshua Fairfield writes about this extensively in his book, Runaway Technology, and says, let's pump the brakes. We don't need new legal terms and concepts. We have perfectly adaptable existing ones. And then, more innovatively, the work of people like Jana Norman and her award-winning book, Post-Human Legal Subjectivity, where Jana introduces this concept of the cosmic person and sort of explodes our notion of the natural human person and says what the problem is we're always looking at other things in relation to humans. What if it is humans that need to be expanded into everything else in almost kind of like a Buddhist non-personal subjecthood? So I think this is, again, not surprising that it was award-winning, but a different way of thinking about how can we sort of refresh, revitalize, and reinvent legal concepts to be more responsive to meet the challenges of our technology age. So again, this is extremely tentative, so I'm sure you've all thought about this in greater detail than I have, but what I've been thinking about is, well, what can we do moving forward? There's a couple of things that we can consider. One is to make animal-sensitive AI law. If you are following, and I have a slide about this next, AI developments in regulation, at least in the United States, I mean, it is, the sort of modus operandi is move fast and break things. It is not be careful and don't harm animals. So we could see about, in terms of what Carol was talking about, advocating that AI law have animals incorporated into it, and then the sort of flip side of that coin is AI infused animal law. So whether it's animal welfare law or other kind of animal legislation, but thinking about amending it to bring in AI where it might present novel challenges to protecting animals. And so that's just another, whether, we're adapting concepts like fairness, privacy, and so on. So you probably have already talked about this a little bit, but I think it bears repeating, especially since I'm probably somewhat certain that we haven't talked yesterday about the second point here. So the US is in the move fast and break things way of regulating AI or not regulating AI, focused primarily through a national security frame, the idea being that we need to beat China at all costs. And so therefore it is incumbent upon us to do whatever we can to marshal all of our resources, to put all of our energy and dollars into having the fastest, best AI, no matter what the consequences are. That is the sort of dominant strategy right now. We are light years away from the AI Bill of Rights that was proposed during the Biden administration. Don't expect that to be resurrected from the grave anytime soon. The other thing, which I think is really interesting and that I have not seen a lot of people talk about, is what's happening at the state level. So I am one of someone who's one of, I think it's 2 or 3 states that has seen the clawing back of the rights of nature, right? So what happened in the state of Florida was we had a popular referendum to grant rights to the Wekiva and Occoquan-Lockhatchee River. And then we had this sort of legislation that was very, very innocuously named called the Clean Waters Act. And in the Clean Waters Act, there's this little provision that says, grants the state government local preemption to prevent any kind of, whether it's a referendum or local law, like an ordinance, that would extend personhood or rights to natural entities. So a judge rightly found that Orange County was in violation of the Clean Waters Act when they passed a popular referendum that extended rights to rivers. So after Ohio, I think Florida became the second state in the country and second maybe municipality or jurisdiction in the world to actually remove rights of nature from the books. But that's not what I want to talk about. What I want to talk about is what's going on in other parts, specifically the Mountain West. So there are 3 states in the Mountain West, North Dakota, Idaho, and Utah, that have banned legal personhood for all non-human entities. And they have a literal laundry list. AI, animals, nature, for some reason, celestial bodies. And what's really interesting about this is that 2 things. One, if you watch the legislative debates surrounding the introduction of the legislation, they don't talk about AI at all. What do they talk about? These nefarious attempts by these no-good advocates to legislate rights of nature. So then they went from that to a laundry list of every conceivable non-human entity, including AI. And what's so surprising about that is there is a parallel but exact opposite approach also happening at the state level, where about half of the states in the United States have what are called personal delivery device laws on the books. These are laws written by lobbyists on behalf of a single company called Starship Technologies that otherwise I think has a pretty harmless goal, which is to create legal pathways so that they can operate their products on public thoroughfares like sidewalks. So all of these laws, including in places like Virginia and my home state of Florida, say something like all personal delivery devices shall have the same rights and responsibilities as pedestrians under similar circumstances, which in some jurisdictions is equivalent to how they treat bicycles. But here we're talking about autonomous vehicles, right? And something with a sort of a commerce-related function. So I've asked their legal, their chief legal counsel, why did you have the legislation say the personal delivery devices, why not the operators of the personal delivery devices? I am still waiting years later for that response. But you see what's going on here? So on the one hand, we have a preemption at the state level, which is banning legal personhood for a whole host of non-human entities or the more than human world, at the same time that we are extending direct rights to robots, possibly for corporate accountability or evasion of responsibility. The center cannot hold when both of these things are happening simultaneously. So I think that this is an interesting thing to watch. As someone who, in early in my career, focused on norm fusion and norm diffusion, seeing this happen in the Mountain West, it's only a matter of time before we start seeing it happen in other parts of the country, maybe other countries as well. So pay attention to what legislators are doing on the legal personhood front. By the way, there are carve-outs for corporations, obviously. And if you read the Dobbs decision, like some of you have, I'm sure, given your interest in the law, what's really interesting, and I would really encourage you if you're focused on things like legal personhood, is read the paltry paragraph about personhood in that sprawling decision. The latest citation in that part of the decision comes from the 1990s. It was written by a law clerk who doesn't know what they're talking about and has not read up on all the things, including what people in this room have written about recently. And it doesn't push the ball forward, it basically punts on the issue of personhood because it's so thorny. So for further reading, if you're someone who's interested in this, I can recommend the following, of course. So there's people in this room, Yip Fei, has been at the vanguard of this, so I recommend his work on a couple of these items, or I guess 3 of them, right? But these are all great articles, which if you're looking for a primer in the intersection of AI ethics and animals, this is where I would recommend checking out. So I know that's a lot of ground that I covered, and I hope I've provoked some thought, so I will leave things there, and we'll have a good conversation. So thank you very much.
Okay. Well, first, thank you so much. That was outstanding. So we have about half an hour, and I think what our thought here is maybe we can have a little discussion. But we've been having a lot of discussions in this conference. This is also going to be opened up. So let's push it, and let's kind of take that primary point you said of how do we move forward. So if I can ask you your question back, which is, you don't want us to have a human-centered conception of the law. And you've provided a bunch of things like Earth system governance and stuff. What would you like to see in a generation the paradigm be?
It's a great question. I would say moving to, and I'm certainly not the only voice here, so I want to kind of give credit where credit's due, but there are a lot of folks who talk about legal pluralism and or the concept of a sort of pluriverse. And I think that is a tricky but productive way that we can honor and respect how other societies are dealing with these same issues without imposing a kind of top-down perspective on what that law or what that legal decision-making needs to look like. So that would mean different ways of interfacing, and I would say also extra-legal, right? There's a lot of interesting work, which you probably have already talked about, on how can we account for animal interests using AI. I just watched on the flight here, The Loneliest Whale, and the documentary about the 52 hertz whale, or whales, as it turns out, spoiler alert. And I think that there's folks like, the Sentience Futures, Animals in the Room Project SETI, thinking of innovative ways of actually harnessing technology to give us greater insight about interests of the more than human world. And it may not be as clean as simply updating legislation to allow for animal inputs, but it could be completely different kinds of decision making that are sort of quasi or extrajudicial, again, based on the kind of community, in order to provide opportunities for decision making to happen in a way that is autochthonous within those groups and societies. So I guess a long way of saying that I'm not going to propose like a single legislative language that we could adopt that would sort of be a cure-all for things. But I think that is a decision that has to ultimately be made within sort of different communities about how they want to govern the worlds that they're overseeing.
Yeah, thanks. Maybe I can just follow up on that quickly, which is, are there any sort of landmark decisions or laws or sort of moments that we should aim to achieve ahead?
You know, I at the risk of kind of making it seem like I'm talking out of both sides of my mouth, I think that the Estrellita monkey case is actually quite good for the reason that it at least addresses the sort of twin concerns of animal rights and the rights of nature. I think the problem that I see is that there's too often a reliance on one perspective without considering the merits of others. So, and I would say that applies equally, right, on animal rights, but also the rights of nature. Never betwixt shall they meet. And I think that's problematic because it means that we're often talking past each other. And so one of the things that I really appreciated when I had the opportunity to read Yipfei's work earlier was kind of breaking those barriers and thinking about the ways in which these lines of separation that we have set between different kinds of entities are being brought down. I at the risk of also making him embarrassed, Jeff's book, The Moral Circle, right? It's not called The Animal Circle. It's not called the Natural Circle. It's The Moral Circle. And it's about how we can address on a sort of moral philosophical basis all of these different entities with whom we share the planet. And I think that that is the biggest thing that I'm trying to advocate for, is just not thinking in silos. And it means breaking those down. So I think Estrellita monkey case is an example of that. I think that the Panama sea turtle law could go further, because I had to read that several times to figure out why are people making this connection between what it says in the law and what they're deriving from it. And I think that we could make those connections more explicit. So when laws are being proposed, and what tends to happen right on the rights of nature side is you have like a couple of organizations that are spearheading constitutional design processes, or being, I read this one article that called them constitutional Johnny Appleseeds, and going into different jurisdictions and basically writing the laws for them. I think we need to think about, again, thinking on a more than human basis and also on a legal pluralistic basis, so that it's not going to be simply a one size fits all model, but it means it's also hopefully not going to be a one entity fits all model as well.
Yeah, thank you. And, anytime, please, anyone just raise your hand, right? Like, we'll just kind of do this. I think something interesting is this question of what's the sphere, what's the scale, what's the resolution. It sounds, you have a background in systems. Jeffrey West is a complexity scientist at Santa Fe Institute, and, shows that some of the same things that are operating as rules in organisms are operating at city scales. And so, one of the challenges that we face in general is what scale and how do the rules operate. And there's this distinction that we've all been identifying between property and person, but there's also between persons and populations, right? And you're really targeting that in your discussion around ecological thinking and sort of, I think you're sort of saying animal perspectives, which are almost in your light too individual focused. So I'm just kind of presenting this as what's the cut that lets us at a certain point classify.
Yeah, this is a really thorny question because of the level of societal organization that we've all collectively bought into. I'm a political scientist first and foremost, so sovereignty is always regarded as the most important norm in the international system. And yet, on the other side of things, as someone who does environmental politics, there was a move like a couple decades ago to recognize the importance of bioregions. Even in an era in which climate change is having all these impacts, our bioregions are changing, irrespective of the boundaries. And what's, I'll just say as a sort of side note, what's really interesting is when you bring these issues to the attention of students, it is like, telling them that Santa Claus isn't real for the first time, because they have so bought into as taking for granted how we have arranged ourselves politically that it doesn't strike them as problematic, or they have no sense of an imaginary that we could think at any other kind of scale. And so I'm not going to necessarily argue that I myself am adopting this, but what I will say is that there are folks now, I would say adjacent to the Earth System Governance Project, who are thinking in planetary scales. Whether it's, we are crossing planetary boundaries and talking about planetary justice, as opposed to thinking on sort of the micro scale or even, city block on up. what we risk there, of course, is if you don't democratize that in the right way, you wind up washing out or diluting the important voices of people who are affected by these larger structures. And I don't know if anyone has the right solution to that scaling problem, but I think sovereignty ain't it. And we do need to think about maybe deciding global and acting local, for lack of a better phrase, because I think that there are certain, microcosmic things that are very important. We do have micro regions, right? But at the same time, if we lose sight of the larger systems that we are inhabiting, then it becomes easy to not think about animal agriculture in South Asia, because that's not here, or how we are consuming in the West affects climate change in small island developing states. So I think a problem that is featured in animal rights about this sort of ontological disconnect between who we are and what we consume is also similar to what we see in our own governance structures, where our decisions have ramifications far beyond our borders, but we don't consider them. And in fact, right now what we want to do is hermetically seal ourselves off from those other places and act as if we are these, separate, siloed entities that are entirely capable of dealing with each other. But I'll, spoiler alert again, butterflies don't care about your borders.
Okay. Maybe I'll not push back, but try to give you a framing. Yesterday, I sort of tried to present a back to the future perspective. I think a lot of these are classical considerations that we are now bringing back. So you're talking about biosphere, you're talking about technosphere. Chardin, you know who I'm talking about, had this idea of a noosphere 100 years ago, right? He was a priest who sort of said the world is coming together and we're going to start thinking about this. And we've had 20th century of lots of efforts to say, let's have global orders. And in this current moment, in really real ways, anti-globalist movements, local sovereignty movements are also doing things that are very practical, like saying the EPA impact monitoring should not be mandatory, right? Mm-hmm. So you're seeing this dialogue of everyone trying to figure it out, okay? And so I think that, my question is going to be, okay, so you also, I'm just chatting, you brought up Fairfield on adaptation, right? So our current frameworks and how they move. And then you brought up Norman on their new tools. And then you brought up this place, you said this, you quoted Yeats, right? So the center cannot hold, okay? Because there's starting to be a conflict between different framings of this. So I'm just going to give you one example and then do it. There's a legal concept that probably everyone's familiar, not everyone, but maybe is familiar with, of deodand. So what's a deodand? A deodand is an object which, or an instrument, which is involved in a person's death, okay? So a runaway train trolley problem, or something that collapses and kills someone. And for 1,000 years, the law, and the common law was forfeiture of that object or instrument, or in fact destruction of it. And in fact, that was even applied to non-human animals when a horse or another entity would be responsible for the death of a human. And around the 1860s, once we started having a lot of trains, you started having mass accidents where many, many people were killed, and maybe corporate interests came in and said, no more deodans, okay? And so today, and so that actually denied responsibility, liability, all these kind of things. And then today you have Air Canada's chatbot saying this, right? So I'm just kind of setting it up for you, but I sort of want to argue to you that not only it's not just adaptation, it might be more sort of return to what those concepts meant in the first place when you ask about what is liability, what is framing, what is responsibility. So take all of that, take whatever I say. Is there a concept of American constitutional law, originalism, let's say, where you think it plugs into rights of nature, where you think it plugs into these, and that is sort of, we're proud to be American, if we're saying it that way, and we think that that is how we are advocating for these next advances of sovereignty or these kind of claims. So thanks for letting me talk at such length.
Yeah, no, that's a great question. I admittedly have like a very poor answer for, and I think that there's sort of, I think, two different issues here. One is there an actual concept that I could point to and say that this one is maybe superior in the sense of how it used to be interpreted, and a separate but related question about how could we better frame things so that they maybe have better uptake or widespread acceptance. And I think I don't have, from the Constitution, famously one of the oldest and shortest in the world, a whole lot. Someone who started, my career focused on comparative constitutional design, I was astounded with the diversity and complexity and longevity of other constitutions, and our utter unwillingness to even consider that any of them might have anything to teach us. And then, all the folks, Mark Tushnet and others who focus on comparative constitutional law, I mean, they, clearly see the value in all this, but it's like almost a dogma that it's not worth our time to look at other constitutions. And then I think it was 2010 when Kenya's constitution came out, and it had like a page on environmental rights, which was just mind-blowing. In a great way for me as someone who was studying environmental rights. Where I'm going to build a bridge here is when I was doing my dissertation research, I had a very empirical question as a social scientist, which is very simply, why did some countries have environmental rights in their national charters, and why did some countries not do that? And I sort of set this up as a dichotomy. And when I did my field research in Nepal and Sri Lanka, I came to a realization on the Sri Lanka side, which was I basically coded my case incorrectly, because I have a book by Environmental Foundation Limited, which is one of their biggest and oldest environmental advocacy or public interest law firms. And the whole book is called Your Environmental Rights. And this was a country that I had tagged in my data set as not having environmental rights. And to them, they did. And it's because not only had they attempted successfully on several occasions to insert environmental rights into their constitution, which was first in 1978, but they found other ways. And so I think that's kind of maybe how I would respond is maybe it's, I'm not going to say anything controversial here. Our Constitution is hard to amend, right? So we may have to think about kind of alternate governance structures and how those might play a role. So in a way that this might chip away at something I said earlier about sort of the global, right, order of things. But Florida is definitely not a great example of this, where we tried, darn it, we tried so hard at the regional county level, and then we're just clapped back by the state. But I think more experimentation in these pockets is where you're going to see that innovation, because some of our existing systems are so rigid and totally antagonistic against the prospect of updating and amending and things like that. So I would say if we have learned something from our Constitution, it's to not do another thing that looks like our Constitution. And instead, it's to trust in what happens at the local level to be these laboratories of experimentation. And I would sort of counter a bit of what I mentioned happening out in the West is I would say we should see states legalize non-human personhood, as a way to respond to what is happening in places like Utah, North Dakota, and Idaho. Why don't we see that happening? And I think it would be an interesting coalition of actors, and I'm sure Jeff could back me up on this, where you would get people from the animal rights community, from the rights of nature community, from AI rights and welfare communities, all saying we should figure out what this looks like, with the objective being that we're trying to create a better world at the end of the day. And we think that that better world means protecting a range of the more than human world, not simply just unborn entities or existing human persons. Yes.
Yeah, as you're talking about that, I mean, the sort of individual rights versus rights of nature and all of that, and environmental rights, I've been trying to figure out how to exactly frame this, and I'm not quite sure, but even to the extent we think of environmental rights, and even what these other countries are doing in terms of giving rights to the river, isn't it ultimately, though, for the benefit of humans? We're not, we're protecting the river because of our humans' use of what we need from that river, right? And to me, that's ultimately the biggest problem. We're not seeing necessarily the intrinsic value of whatever the entity is, whether it's a natural, entity or a non-human animal, but we're always thinking of it in terms of because it's to benefit us, right? And then the whole individual animal rights perspective versus sort of the populations and protection of populations. That's been obviously I guess, and so two different frameworks, very different from an animal welfare versus environmental law. And I mean, the notion of compassionate conservationism has been a group that, or a paradigm that has tried to wed those two a bit, I think, in terms of thinking about individual animals' interests versus the rights of the population, things along those lines. But my point being, where do humans fit into all of that, right? I wouldn't think that you would, individual human rights are going to be around, and we don't think of individual humans and their rights and infringe their rights in the same way we would even under an individual non-human animal rights perspective. Do you see what I'm saying? So I got sort of two different questions that I've got going on there, or two different thoughts, I guess, that I've got going on there, and I was just wondering how you might respond to that, if that makes sense.
Yeah, so the first question, if I'm hearing you correctly, is about sort of the place of nature. And the second question is really about the place of humans.
Okay, and the place of nature of humans, but for what purpose, right? Is ultimately to protect human interests, right? Isn't it?
Yeah, so to the first question, the environmental ethicist Holmes Rolston talked about this and said, the moment that a human leaves nature, the rights leave with it, right? And even in the research that I did comparing rights of nature cases across the world, all of them initiated because of actually not a harm to the natural body, but some kind of human element, whether it was a road, pollution of a river that affected people. So the cause of action was never that there's a discernible, cognizable, empirical harm to the quality of water in a nearby body. It was always because the humans were being impacted first and then had a reason to kind of draw upon the rights of nature. So I think that in a kind of more egalitarian paradigm, you would have to have a cause of action where there's no human interest. And I think the closest that we get, if we're going to borrow anything from American law, is like the Endangered Species Act, and thinking about like the snail darter case. I mean, those types of instances were like unfathomable when you think about like the Industrial Revolution, that we would actually enjoin development because of a bird or a bug. And so I think that that's at least a sign that it is possible, even if it is still quite difficult. And now, of course, we're in a completely different scenario in which it's very unlikely. But finding out what those interests are and seeking to protect them, the way I would build a bridge to the second part of the question is, one thing that I kind of found myself very attracted to, sort of at the tail end of graduate school and early in my career, is critical environmental law. And one of the insights from critical environmental law, well, I say two of them. One of them is, Anna Greer talks about this as like a tentacular amoebic function, which is that environmental law, at least it's sort of an ontological aegis, expands and contracts based on situations, which is not something that law is very good at doing normally. And the other insight is that it has to be capable of demoting the interests of humans so that it is decentered among all of the more than human world. So the way that I usually characterize this is, it has to be the case that in a court of law, a human has to be capable of losing. Because if that's not the case, then everything is always already anthropocentric.
Just to follow up on the ESA really quickly, I mean, the Endangered Species Act, they don't care about the individual snail darter, right? We care about not losing a species of animal because of what potential benefit we think we would gain from them, and we don't want to lose that benefit, right? It's not about, again, it's definitely about protection of the species, not about the protection of any individual animal, but even then, we're only protecting the species because of the benefit we think humans will derive from it, right? And the whole notion of biodiversity in terms of not wanting to lose that species for some human perspective.
That was my fig leaf to American law, and you threw it right on the ground.
Yeah.
Thanks for the interesting conversation. So I'm from Australia, Christine Parker, and I mean, we have a lot of rights of nature things happening in Australia and New Zealand, but we would never talk about it without talking about the traditional owners or the Indigenous groups, because it's very tied to I mean, it's really been the advocacy and the work of those Indigenous groups and the recognition of their care for country and their relationship with country that's led to those developments in Aotearoa, New Zealand, and the river in Naarm, Melbourne, that I come from. We now also have the voice of the Yarra, the Birrarung Ma. And so, yeah, we always talk about it with a lot of respect for the traditional owners. And I think I want to dispute the sort of human animal binary there, because I think when we listen to the traditional owners, and I think a lot of us feel this way, we don't see it as quite such a binary, because they will see themselves as part of country, caring for country. We don't. They dispute this idea that there's some bits that are wilderness and some bits that are human, and I think we're all trying to learn from that. So I guess it's a kind of different, more relational or eco-feminist ethics. I mean, you mentioned Anna Greer, which I think, goes more in that direction. Yeah, so I mean, I know it's a bit more difficult here where colonisation and so on happened earlier, and there aren't the same legal institutions around developing around traditional owner rights. I mean, I guess we can see all these things. We can choose to see them in a more negative way, or we can choose to see them in a different kind of way. But I'd like to give an example, like our sort of equivalent of the Endangered Species Act. What has happened with the conservation plans for some of the species, I should say now, is that in the traditional owner areas, the conservation plans, and that's a vast majority of northern Australia, northern Queensland and the Northern Territory, the conservation plans for some of the animals like the sea turtle, the big turtles, I forget what they call them, and crocodiles and so on, are now developed with the traditional owner groups. And often it's the traditional owner who, the subgroup who have that animal as like a totem, who will protect that animal. And so it's a very different way of thinking about the relationship between human, animals and ecosystems, a very holistic way. Anyway, I just thought it was missing from the conversation. I don't know whether we have...
Yeah, I mean, I really appreciate that. I'll say that my sort of homage to that was the pluriverse. And that was thinking about how different groups, especially non-Western and Indigenous societies, which I write about quite a bit, conceive of the world very differently. And even in the case of AI, there's a great series of articles. It was an award-winning issue of, I think it's the MIT Design Journal, and it's from Indigenous scholars, and they talk about how varied their relationships with technology are in ways that I think people in the West would even find quite innovative. And so I didn't mean to sort of gloss that over. Last year I was very fortunate to be able to do an event with Robin Wall-Kimmerer at our Kummer Museum in Jacksonville. And she talks about both in the serviceberry and in braiding sweetgrass, the idea that humans are just sort of but one entity. And in fact, she goes on to say that, plants are considered like a higher life form, and that humans are quite low on that list in terms of the level of evolution. Again, that would be heretical in a Western legal setting. And yet, it is something that we should absolutely be listening to and provide the space for agency and authority of people, traditional landowners on their own rights, because so much of that has been lost. And you're absolutely right. The other Rights of Nature conference I went to was at the University of New South Wales, and I mean, all the conversation there, the edited volume coming about that is something called rivers have rights, now what? And but the thing is, it is the rights of nature conversation in the US has proceeded very differently. Years ago, I was at the University of Florida Law School that did an entire conference on this. And I remember going to sort of the opening plenary session. You could not find a single indigenous person in the audience. Who was it? Who was there? Young law students and old white retired environmental advocates. That's it. That's everybody. So that, I think, is much more indicative of what the rights of nature movement is like in the US. It is not the same as it is in places like New Zealand and Australia. And I think to our detriment, because we miss out on these insights that, frankly, we should be heeding, that will help us to address some of our challenges in ways that are ethical and beyond, frankly, some of our ways of thinking about the world.
Can I just ask a follow-up to both of you? So this sort of relational responsibility, and then actually instituting it. So when you talked about P719, IEEE's P719, how, the machine eye perspective, let's just say, is there a way that these things come together in terms of how you develop standards and try to say that? Or is there a way that there could be, whether here or comparatively?
This is a good question. I'll just give one example because it was discussed in the previous panel about deliberately choosing to design AI so that it is AI animal sensitive. And I have a chapter in an edited volume where I talk about more than human justice. And one of the examples I gave is designing these sidewalk robots, these personal delivery devices, to have their computer vision training recognize the diversity of beings that they interact with so that they don't pose a threat to any of them. And so that's kind of a, mechanical way of addressing the issue. You could expand that to include how AI is interfacing with the broader natural environment. It's a big challenge, right? Of course, because so much energy and land and water is being used in the production of AI and the deployment of AI. And now we're having companies talk about putting, AI data centers in outer space. Like, why not colonize that too, right, while we're at it? So I think we're definitely putting the cart before the horse in terms of how we do these things, again, because our approach is move fast and break things. But I'm really glad that there are places like this, the work that Andre is doing with the IEEE group, to think about, well, what principles from Earth law could we identify that could be useful for the future development of AI? I don't know if I could name all of them off the top of my head, but I think I would encourage everyone who's curious about this to read that paper because it really lays out in sort of sprawling detail what that would look like. So Andre could say it better than I ever could.
Yeah, well, thank you. Maybe, and we also may want to unshackle the horse, right, from the heart. Sam?
Yeah, do I need the microphone?
I'm coming.
Okay. Hey, so just like a bit of context, my background, I'm actually from the iwi that got personhood for the river in Aotearoa, New Zealand, Te Awa Tupua. So yeah, like there was kind of that discussion before about like, has legal personhood been achieved in a way that doesn't kind of recognize what sort of, the role is, the impact on humans in a way, right? So with that sort of like worldview, the belief there was that like the river was essentially our ancestor. So that was sort of like the legal basis for the claim, which I think is probably like different than saying that it had an impact on us. And also like the sort of Māori worldview is very much like inverted, kind of like what was being talked about before, where like plants are like higher beings, but in a slightly different way, which is where you come from is kind of more important than who you are. So basically, like when you introduce yourself, like traditionally, you say like the boat that you arrived on, the mountain you landed at, the river that you came through. Then you say like your ancestors, and all of that becomes as more important a part of who you are than who you are as an individual. And so I guess the question that I had was about whether or not you could kind of invert this framework with like thinking about the legal obligations we have in respect to AI. So it's like there's kind of this precedent, right, of us treating the river as our ancestor. Do you think that there's a potential legal framework for sort of thinking about AI as our child, something that we have guardianship over?
So that's a great observation and question. And I'll say that first, I'll defer back to that special issue with Jason Lewis and some others, because they talk about this in in a way that a white Westerner never could. And I will also say that, again, I'm really glad that we're having this conversation, because that idea, if we replace this setting with an AI ethics conference, I mean, people will be throwing tomatoes at you, because of the personification. And so many of the people in AI ethics are so worried about the risks that we run by anthropomorphizing, that I think they would shut down the premise of that question, which is really unfair because it's coming from a place of curiosity and cultural awareness. So I just wanted to kind of like highlight that as sort of a meta point, that if you ask that question at AI ethics conference, like people would be walking out of the room, because they would see it as trying to achieve the exact thing that they are against, which is to find a way to humanize the AI, because they feel like that is inherently bad. So I certainly welcome that question, and I would be curious what other people would think. But I just wanted to make that point, that like that framing is so controversial in that community that it probably, I would love to be a fly on the wall when that was discussed at like an ACM conference or something.
So I know that we're over time, but lunch is a little late arriving. So if you guys are happy to continue talking, okay.
Yeah.
Then one quick question that I have is, it seems like there might be a distinction between legislation and litigation for these conversations, because the concept of Pachamama and the concepts that have been discussed here, I see actually fruitfully recently, and to some small degree, included in legislative initiatives, right? But the challenge about the human harm comes back when we get to litigation, right? So what is the reason that we get into court? And the legislative protection is still where we have it, not strong enough to be present in court without the human standing, if you will, right? And I don't know if that's an accurate, so that's what's occurring to me through these conversations. And I don't know if you both see that as an accurate dichotomy that needs to be addressed.
What do you think?
So, can I just understand that at the center of it? Can you say it just like the...
Yeah, so some places are including indigenous, tribal, and traditional perspectives into legislative protections, right? Mm-hmm. So whether it's rights of nature, Pachamama, all these different framings, but when we get to, so we have theoretical protection, right, for these concepts, and then when we get to court or when we want to go to court to protect them, that's when we come back to the human-centered nature, right? That we have to have a harm to the human to bring us into court to validate these concepts that aren't supposed to be tethered to humans.
Yeah, that's great. I think we live in a contemporary era that is highly superstitious, and that has yet to reckon with both the Copernican revolution and the Darwinian revolution, that reality doesn't revolve around humans. And I think that is very, very explicit in how you think of even biomedical scientists and the way that they conduct medical research and think about biological systems and healing them. There is sort of an insistence that is an axiomatic superstition of sort of, now let's drop reason and reclassify. So I think that's across things. I think that's obviously a challenging thing. So, I was having a wonderful chat earlier with someone who comes in as an advocate in animal cruelty cases, and is able to represent, sort of saying, hey, we don't want to do that, we want to be appointed as the advocate. But they're not legally, statutorily appointed as the guardian ad litem for the dog or cat or horse who's faced cruelty. They're sort of the broad social interest, okay? So I guess I think of it as that is what we're facing. That's your question of what does it mean to always bring it back to the scala natura of human-centered. I do think, maybe this is just the only thing I would say, yesterday we were chatting about AGI, right? Artificial General Intelligence. And it's this conception often said of compared to humans. But a real sort of machine that can match or exceed all biological intelligence would be able to make a spider web as well or better than a spider. That's what real AI is, right? And so I think that when you start to ask these questions in the law, it's sort of justice by whom for whom, right? And so I don't have an answer, of course, but I think that the question is almost in consequences. Where is it a place where if you didn't make it about the human as an individual or a population, you'd have winning? And I think that connects to your point of you may have to allow for a certain paradigm to lose, but it may still be very good for humans. So I'll stop there.
I mean,
How do we win by losing this current paradigm, I think, is the thing, right? How do you win the next paradigm by losing your commitments to this paradigm?
So I'll say I don't have an easy answer for this, but I think the source of the problem is the ethic. And this is what a lot of it comes down to for me is that, when I'm like reviewing a paper, I remember I asked once a person who had written a paper at a We Robot conference who was deeply critical of my book, which, for people in human rights, I presented at a human rights conference and people were like, what is this guy talking about? But oftentimes it's because people have never interrogated the suppositions underlying human rights in the first place. Then you start needling at them and then you realize, oh, that doesn't make sense in this context. And yeah, this consciousness, like, this sentience and so on. So anyway, when I asked this person who wrote this, very negative I would say it's one of the worst piece I've ever read on the topic. But I said, how did you arrive at this critique? What is the ethic or the ethical orientation that you are using to make these criticisms? I didn't have one, right? Which is like the critical theory answer par excellence. So I think to me, that's the problem, is that we're not starting, and on this, I would put myself in like the relational camp on this one in terms of the, moral status of AI, is that you got to start with that. What does it mean to be good in the world? And everything else flows from that. It's now, granted, this is kind of hard for to do this in sort of a legal audience where you're approaching it from, well, what does the law say, right? But we think of, whether we're talking about the moral status of AI or anything like that, that there is oftentimes, if not always, a transition from moral rights to legal rights. It's very difficult to leapfrog the moral question and go straight to the legal one, although ships are a great example where, again, people who are skeptical of this, they never have a good answer for this, right? It's like, well, yeah, but corporations have people. Okay, where's the ship? Well, people built the ship. Come on. Really, no one actually anthropomorphizes the ship. The whole reason why the ship was actually granted any kind of status was because there was no way to resolve conflicts, legal human conflicts, in the absence of the people responsible. So they said, I don't know, call the ship the person or whatever. And that became the answer. That is not an ethical solution, that is a legal one. So for me, the question actually turns to, what are our ethics? How can we design better ethical approaches to being in the world? And I think that the law will flow from that, whether it's indigenous, non-Western, again, things that are oftentimes quite marginalized in these discussions. When I used to have these conversations, like around the pandemic, especially if you talk to a European philosopher, like a continental European philosopher, it was like talking to a wall. They can't free themselves of any of the assumptions that they were raised under. And I think that is where all these problems begin to emerge, because we have these things like AI, the possibility of AGI. I love the way that you talked about making spider webs. I'm going to use that. And people aren't prepared to think in these extremely disruptive, dynamic terms. And they are, much more comfortable in their little boxes. And that's how they understand the whole world. So I think we need to actually look outside of ourselves, our immediate communities, look to how other societies have dealt with challenges that they've been facing, and then always begin with the ethics, not the law. And we will eventually get to the law if our ethics are in order. Okay.
Well, thank you, everyone. Thank you, Joshua.
Thanks, everybody.
Wonderful conversation.